Good morning. Welcome to the 6th episode of On the Mic. My name's Mike Albee. This is Jonathan Solorzano. We're both licensed attorneys in Arizona. We're here to give you free legal information based on frequently asked questions that we receive from clients. Please understand this is not legal advice and we are in no way forming an attorney-client relationship. Today, we're talking to you guys about settlements in all forms. In my area, in the family law realm, there's settlements called a Rule 69 agreement or a consent decree. Rule 69 agreement is when you're going through a custody dispute, and prior to going in front of the judge, both parties reduce to writing decisions based on child support, legal decision-making authority, and parenting time. Sometimes paternity as well, but generally that's already established. In addition to that, a consent decree is when two parties who are divorcing come to settlement terms on all issues. Settlement, in my opinion, is the best way to go, because especially in a custody dispute, because you're more likely to have follow-through. It's scientifically proven that if you come to the decision, you are likely to act upon that decision. And when you get in front of a judge, who knows? I mean, the judge could end up looking at all the facts, and all the facts can be on one side and then completely rule on the other side. So it's a much safer way and a much more amicable way and a better way, especially if you're dealing with custody, to start to co-parent and come to mutual agreements with each other. And I know, Jonathan, you in personal injury and some other areas of law, you deal with settlements, don't you?
We do, and we believe that, well, for example, in personal injury, I think 95% of our cases are settled before getting taken to court.
I think it's 94.7%.
It might be. Okay. But the important thing to know is that settlement is a more cost-effective way also, because taking a case to trial, to a jury trial, might be very expensive to the client. And like Mike said, you have an uncertainty as to whether you're going to win or lose. With a settlement, you know you're getting what you're negotiating, and that's important. With personal injury, it's important that the client knows, when we're doing these informational videos, that you have the last say in what you're going to take in the settlement. So even if your lawyer says, you know what, Jonathan, I think this is a great deal that you're getting, you have the last say, and you can say, you know what, I want to push forward, or I want to take this to trial.
Following up on that, you always have the last say. We are your advocate, but you are the person making the decision, and I think that's really important. And on personal injury as well, is there a certain time frame that you have to settle the case?
Well, in Arizona, there's different time frames to file a claim. You know, it could be 2 years, it could be 6 months. It all depends on your case. But following up on what we were saying about the settlements, is it's also important to get an attorney who's not afraid to take a case to trial, because that will help you negotiate a better settlement. If you have an attorney who has a reputation of settling out all their cases, the other side probably knows that and knows that you won't take this to trial. So get an experienced attorney who isn't afraid to take it to trial, but who is good at negotiating and will get you the best settlement that you can.
That's a great point.
Yeah.
Thanks again for joining us. This was the 6th episode of On the Mic, and we'll see you next time with more information.